For the past 10 years, 20 years, 30 years, Nigeria has been having challenges that are beckoning and waiting for answers and solutions. That is why we are bringing to you our program, State of the Nation. And this is going to come up on our flagship program this morning on ITV. I am hereby inviting you to join me, Bola Bakare, your host, on State of the Nation, so that we can hasten the motions that brings national development. It's going to be a regular basis on Tuesdays. Make it a date with me. I'll be there waiting for you, and then we shall discuss Nigeria on an holistic level.
Welcome to your lofty program, State of the Nation, where we hasten the motions for national development. And when it comes to national development, you're part of it too. Our discussion this morning is going to bother on the element of our judiciary. And it is about the top dog of the judiciary, the Chief Justice of Nigeria, which we call C.J.N. Our C.J.N., Mohammed Tanko, has just resigned his appointment, for which Nigerians are typical us. We love information, we know we need to, and we want to know explicitly what is happening, why that occurred, and then the whole gamut that culminated into that resignation. Some school of thought are saying, well, the man resigned on the basis of his health. Some school of thought say he resigned based on the allegations of his co-justices. Some are saying he has to resign because to allow for better information. But the idea is we need to talk to somebody in the judiciary to give us some insights about what is going on, so that we can understand better rather than jump into conclusions that are unfounded. With me in the studio this morning is none other than my brother, Barrister Ahmed Tanimu. You're welcome to the program.
Good morning. Thank you for having me.
And to your viewers, I like him for one reason. He's not just a barrister, he's an activist barrister. Because he says it as it is. He does not mince words. Within the dictates of the law, he applies that his professionalism in whatever he says. And honestly, the best thing I can tell you this morning is to put down your listening ear and then be able to learn a few facts from what he is going to share with us. My brother, once again, thank you for honoring the invite.
Always a delight to be here.
Good. The news is rife out there that, okay, the C.J.N. has resigned. And you know, typical Nigerians, we want to know the reason why anybody is doing anything.
Sure.
Can you give us an insight? Because some are saying it is based on ill health. Some are saying he was born in 1953. That makes him about 69 years old. They're saying ill health. Some are saying he has to leave because of allegations against him. Some are saying a lot of other things. But from the angle and the perspective of a legal practitioner, what do you think? Let's just keep it at that level of what do you think about his resignation before we go into the nitty-gritty of details.
Okay. For me, we all anticipated that it will come.
Oh.
Yes, it's just a matter of time.
Time, okay.
And we encouraged his boldness, because the typical Nigerian setting,
They don't
resign.
They don't resign.
In his own case, if he didn't resign, it would be very difficult for his colleagues to pull him down. But they fired the Salvador by writing him and making it public in a way.
That's
got
right,
to
that's
public
right,
knowledge
that's right.
that not on him as a person, but if you lead an organization, the buck stops on your table.
Of course.
If they are having challenges, if you've been to the Supreme Court, you look at the situation and the condition that they operate from is very dehumanizing, so to say.
Appalling.
Looking at their exalted position, then if you look at it, age, there is nothing you can do about age.
Yeah, 69 is not too old, really.
It depends.
It's just a few years older than I am.
Yeah, some are blessed to have very good body, but some, considering the volume of the kind of work they do And to be all honest, as at those time, it's not in every jurisdiction that people keep proper records. Okay. Some they don't keep proper records of their date of birth. They only assess them based on their ability to talk and to be able to put their hands across their heads if they are going to school. So most of our parents, especially up north.
But he went to school. He was in school, so we can use the chronology of his schools.
Yeah, if you add that too, then and also look at it from the angle of ill health. There are certain things you are supposed to. For people that don't know, the head of the judiciary, the C.J.N, is equally in by and large, and that is what obtained in most courts. The judicial officers have not found a way of separating the administration of the court system from adjudication of judicial matters. Okay. They are in one way or the other intertwined, whereby they ask the CR, the registry, to always report to them and get directives directly from them. So
we shouldn't be.
We shouldn't be. The registry should ordinarily be able to take care of all these things. So now
and be answerable to the justice of
that court. So when you now have a situation where the C.J.N are responsible for the day-to-day running affairs of the court in a way, let me give you an instance.
Go ahead.
You go to a lower court, the registrar on his own cannot take directives. All the other judges are equal to the C.J.N. All the other judges of the High Court are equal to the Chief Judge of the state.
Because they can become the C.J.N. too.
They are, in fact, it's just by virtue of opportunity. They are equal in terms of what they can do. But for administrative convenience, the responsibility has been saddled on the C.J.N. So you now see that instead of to have a system that is functional, every assignment will have to come through him. Adjudication, expenditures, and the rest.
So that becomes cumbersome.
It becomes cumbersome. So that is, and now when you now have a case of ill health, so it will now be
the situation is now compounded.
Oh. Then they in the allegation they made mention of finding more time to be traveling around with his families and aides and whatever, and same treatments are not being accorded to them.
No, baby, so before you go into that, let me, because that is part of the questions I have gotten ready for you so that you can enlighten us and share your insights with us. Part of what the justices that made it public, the 14 justices that made it public that our welfare here is poor and the C.J.N is not doing anything about it, which is something you are just about getting on the threshold to it. Give us an insight about this welfare package. Because you said something earlier. Short of being the C.J.N, they are all on the same level. Yeah. It is just a matter of opportunity or a matter of appointment that makes you the C.J.N. But short of that, you are all on the same par.
Absolutely.
Are you saying what the 14 justices said about his person is well-founded? 1. 2. Is it cause for his resignation? And 3, how true is that? Are those allegations of the justices?
Very true in terms of the warfare. The warfare is very poor. If you go to
can you give us some kind of insights?
Example. If you travel to other clime, you go to the magistrate. That's the lowest ranking judicial officer. Some of their offices and their working condition is more conducive than what you have for the Supreme Court justices. Yes.
You don't mean it?
I do. What we have been doing over time, over the years, we have manual recording, manual record till this moment, till this day, it's still obtained.
You don't manual?
Manual up till this moment. For
how much can they write?
So you see, that's where the challenge comes in. Even in the other courts, is the same manual recording. Efforts were made to see how they can inculcate and get machines that could do that electronic means. But we tend to wonder who is not in support of it. Some argue that some of the judges equally, because they lack the capacity to be able to be
they are not computer literate.
They are, but they don't have that sophistication required and the training required, and it takes time actually. So some actually are not into them. You see, they have volumes and volumes of books to read from. They have cases. They need judicial officers to conduct extensive research on.
And investigations.
The physical structure of the offices needs a lot of refurbishment. Their own, they complain of working from 8 to 4, and then because of the availability of diesel that will be the generator that will be switched on, then afterwards there will not be, because, and the truth of it is that even as a private practitioner, we work most in the evenings, in the night.
When you are not in court.
When you are not in court, when you have all the focus, all the attention.
Gives you room to prepare all your whatever
and you cannot
have.
go to your houses, your children, family engagement will not allow that. So they are in a situation where they cannot even work from home, and they cannot work in the office because of power outage. At this era, we should be talking of having a solar system installation.
Of course.
These are things that ordinarily should not come out to public
that you don't have power in a law court.
In the highest court of the land. And for people that don't know, the Supreme Court is like the centerpiece. Every other state, on every matter, as deny you interlocutory application in an area court, in a high court,
one bush somewhere,
it can find its way up to the Supreme Court. Matrimonial causes can find its way. Civil, every kind of matter can go there.
So they are inundated with a lot of cases.
If you see, they give attention to political cases. That is why a lot of you don't really know how long it takes. You can have a case filed an appeal filed in the Supreme Court for 2022, and they will be giving you dates for 2028.
You're
kidding me? Yeah, I'm not kidding you. So you now
6 years.
Yes, 6 years on, and you are not even sure. You are not certain that when it gets to that day,
you get a fair
hearing. So anything could come up. The justices could, maybe they didn't say it. It means you are taking another lengthy year. So everybody knows of this problem. That is why a lot of people call for the kind of decentralization of the Supreme Court itself, so that you have it maybe the way you have in the Court of Appeal, and the cases that do go up to the Supreme Court, they could limit some, so that some should end at the appellate courts. And in US, you have Supreme Courts for each state, not only
on the federal level.
Federal level, only the ones on federal level only discuss issue that borders on constitutional matters. So if we could limit ours to say, okay, issue that borders on state versus state, and the federal government versus states, be a constitutional matter that the other courts ordinarily should not have absolute jurisdiction, then, but any other tribal matters should ended in. Because so those things they complained about are there, and it's not only in the Supreme Court. It trickles down to all the courts in Nigeria, all the courts.
Okay.
We will call that the last administration, they made effort to want to set up, I think this administration, a monitoring unit of sorts. They need to do that. Even the journalists
let me now ask you this question that borders on what you're about delving into. Are you now saying that the judiciary is long overdue for restructuring and reforms?
Long overdue. There's a lot that needs to be done in the judiciary, starting from the way things are being done at the moment, the way employments are being done. We give kudos and credit to President Muhammadu Buhari. One, to a variable extent, he has been able to stamp his feet to resist the attempt of having only the children of judges to be employed as magistrate and judge. Before now, that is the norm.
Welcome back. Before we went on that commercial break, my barrister here was trying to give us the details of what is happening that warranted serious restructuring and reforms in the judiciary. My brother, I would like you to continue where you were, because you were saying something in terms of judges just bring in their awards and their kids and make them into magistrates irrespective of qualification of whatever. But let me add this, because it was part of our investigation that, let me use both words, both past tense and present tense. Was it? And is there really a crisis in the judiciary?
In the context for a layman to appreciate, there is no crisis. There is no crisis in the sense that what is happening, it could have been sorted out differently.
Okay.
His attention could have been called, and certain demands and expectations would have been made. But I believe that if you look at their petition, they say they've done it repeatedly and nothing seems to come out of it.
Okay.
The C.J.N. is the head of the National Judicial Council.
Yes.
So
NJC.
equally, these NJC, this is another opportunity, another forum where issues like this could be tackled. So if you have made complaint to him in person and is now still the same person that is chairing the same council,
council that will implement those demands.
So what some call for is for his resignation as the chairman of NJC. So that to allow the council now to investigate, because at best all what they've presented is just allegations
until proven.
It's not proven. So they needed an opportunity where he will be given an opportunity to come and defend himself, to come and explain to the General Council why all this are happening and what role he has played. And for him, he felt because of the burden of ill health and the fact that, for me, I believe he might not want to face the same council to now start
that he hasn't been listening to all along. He hasn't been
listening to all his colleagues. If you are talking of a person is 2, 3, is you can look at it from the point of view of a gang up. The Supreme Court, they are about 21, and if you have 14
that's
coming
about
to you and telling you that you are not representing their overall best interest. If they say they did not really come out to say you are corrupt or anything, no, they are just saying that you've not done enough, you could have done more to protect their overall best interest. So you look at it that it's not the kind of person they will want to work with.
Let me interject you there. Let me interject you there. Are you of the opinion that the office of the C.J.N. and the chairman of the NJC should be divided?
Absolutely. Absolutely. In fact,
and that is something we haven't had in Nigeria. We always lock them together. Just like the case of Attorney General and the Minister of Justice.
It's high time we separate them. The Attorney General should be somebody that has been elected by the people, just like the way you elect the governors and the president, so that
while the Minister of Justice will be
an appointee
a practitioner.
No, an appointee of the government to handle issues
as a ministerial
post. While these will handle strictly litigation issues
against the
government in favor of the government, and nothing more, so that he won't be delving into the realm of politics.
Translate that to the NJC and the CJN's
so you
office.
Now have the CJN that is the
what are the duties of the CJN per se?
Okay, as I said, all of them are equal before the law, but you need to have head in any organization. So the CJN ordinarily, he coordinates the activities of the Supreme Court as relates to cases, assigning cases. So they constitute quorum. You have a panel of 5, and so for a particular matter, he is the one to look at those that could have interest or due to where they come from or their past judgment and the rest. So he now constitute different panel to listen to different cases. He is saddled with that responsibility.
What about the case of the NJC, the council itself?
The council itself has to do with the discipline, the regulation of the activities of all judges. So you now see that he will be a judge
in his own case.
He is heading the judiciary.
Little wonder his colleagues
they just
forced him to a point of resignation.
Absolutely. To me, that is the angle I'm seeing it from. It's a forced resignation. He had no option, because if what was done to Onoge, and which a lot of people, some were having misconception about it, so it's the same thing. There's no clear-cut way of easing out a CJN, so they had to resort to other means. In the case of Onoge, the executive were interested, and his the code of conduct were brought in. In his own case, his colleagues, having used the various means of interpersonal relationship, moral solution, and nothing happened. they decided to write to him and make their petition public in another way. And that is why all this is come. So the pressure and his ill health will naturally make him to come to that conclusion that he can no longer continue to head a group of high-ranking judicial officers that have lost confidence in his person. So I think he did the right thing. Then going back to the issue of the what obtains in the court, as I said, you need to take a visit to various courts. There's a court at your back at the Pape Grade. You see that the judges are overstretched. They are still doing manual recording. The facilities for filing and so many things, and the litigants usually bear the brunt because things that ought to be available are not there. So the court officials will ask the litigant, you that are filing the case, you need to bring money to go out for service. They should have a car, they should have fuel and PMS with the car so that they can go and effect service and the rest. But they are not doing that. So the burden still comes back to you.
So short of what you've just said now, that even in the courts there is no provision for services.
The services are poor.
You're saying the same thing, that when it comes to courts, the same thing that applies in our homes of no power, no this, is applicable in the courts too?
We are part of the society.
No, that's an institution. It's like telling me now that in an hospital where the operating theater and there is no power there, that's a big disgrace.
Well, I have been in court on many instances where due to lack of diesel, we had to take out our wig and gown. We have to be finding ourselves, and the judges will definitely allow that, because anything short of that, it will amount to suffocation, because the heat and the conditions are quite unbearable, and that is how we
then continue. For God's sake, if we have a situation like that, how are we sure we're going to get the best of our judicial system when everybody is uncomfortable out there?
You will not get. You get the worst of it, and that is why we are where we are today. You have cases that are lingering for years. You have cases that by the time you finish reading the judgment, even as a layman, you start wondering what is wrong. You have instances people have lost confidence in the judiciary because of what they see. And that can be improved, that can be changed if concerted efforts. So for me, I'm even looking at it beyond the resignation of the C.J.N. The new person that has taken charge.
Let me go into that. Now that we've been able to look at the parameters that warranted the resignation of Muhammad Tanko, fine, we've been able to lay the facts on the ground that, okay, the welfare is not there, the paraphernalia of office, the enabling environment of office, they're not there. There is no power in the offices. There is no electronic recording of cases. Everybody's still doing longhand in some cases, and then in some cases, maybe a few of them, they have all these electronic materials to use. But at the same time, I believe one thing, that life is work in progress.
Sure.
He has resigned. Mr. President has sworn in another acting C.J.N. in the persons of Olukayode Ariwola. Fine. Now we are having a different person on the seat. What are your expectations from this new man?
My expectation is that he should hit the ground running.
By doing what?
By taking certain drastic actions. Actions that he is aware of, he has complained about, he is a victim of. Okay. And the time to doing that should have even been done since yesterday.
Okay.
Yes.
That's why I said you should hit the ground running.
You should get solar panels, solar systems for the courts.
Yeah,
in all the courts.
Alternative energy.
Yes, alternative energy. These are doable. You get inverters from any court, and you make it a responsibility of the.
It is a typical example is if you go to Ministry of Works and the rest of them, Environment in Mabushi, they've turned their car park into an array of solar panels.
That is what is expected from the courts and the judiciary. They should have public address systems that are functional. They should have digital. They should try as much as possible to digitalize the process. You reduce manual interface. If you need anything, go online, do it. Even though we started, but more
needs to be done,
so that at the end, everybody should be on the same page, and instances of manual intervention will be very reduced, and it will create room for effectiveness.
Thank you.
He should carry all his colleagues along. They are equal.
That's
he should be able to. He should be able to delegate some of the functions that is being performed by him.
There is, from our research, there is that element of overpopulation of the apex court, because there are situations, we've seen some, where some of your colleagues are just moved from magistrate court straight to Supreme Court without the ensuing experience along the line. We have investigated, we've seen, if we've seen one, that one is enough for us to run a reference to. Why is this occurring? One, and two, what do you expect this new C.J.N. to do in this wise? Because you mentioned something earlier, that you've all been having cases where a justice of the Supreme Court will not just automatically pick his son or his ward and throw him into a court. So that without the experience, without the knowledge, throw him into a court so that he can grow along with the system and eventually become a Supreme Court justice. These are things we have been able to research, and these are things we expect the new man to do. But what is your own perspective from the angle of a legal practitioner?
Even the angle of having their wards to be judicial officers, what they do is not that it's illegal, because they are qualified to be judges.
If they are qualified.
No, they are qualified,
okay,
but they are not the only persons that are qualified. You have thousands of Nigerians that are qualified to be appointed as judges, but because their parents are in the judicial sector or judicial arm, they now have an upper edge over every other person. That is what we want it to stop.
Want to erase.
Outrightly, they will not abuse the process to appoint somebody that is not qualified.
Is there no due process?
The due process.
You are now saying, okay, there are 10 of you,
yes,
that have the qualifications to be this.
Yes.
If there is a due process, the due process will pick the best of the lot.
We don't have that.
Okay.
What we have now is there are 10 of you. All of you have been qualified to practice as a legal practitioner for the past 10 to 15 years. So you have made that criteria. Then there's no any other criteria anymore.
You don't mean it?
I'm telling you. Other ones, the length of cases you have handled. So now that's where the instances of, we've seen instances of somebody that is a banker, is barely back into practice, is appointed as a judge of the High Court, whereas his mates have practiced for more than 15 years. They are struggling to get that same position, and you now
shouldn't be, really, because
shouldn't be. You now
the man who has been on the job has garnered a lot of experience.
You are not giving him a shot at the job. Then somebody that just came back from banking, barely 2, 3, 4 years, due to his connection, he has people in the right places, and you are seeing him in that same position. Then you equally have instances of state of origin, federal character issues still plays a very important role, still, even in the judiciary.
Where your mentality, your capacity doesn't come in.
So they look at which state are you from. So all those factors are things that we should have a way around it. We are not saying that it should be discarded completely.
Of course.
But it means that things can be done in a different manner. Let me share an instance. Why not take the best? Why not take someone that has a track record, someone that has good academic qualifications? Why not set an exam and say, okay, based on the
a competency test, based on this test, then the best man gets the job.
So now you now see that they take officials, those who have worked with them closely. So we need to really set some basic standards. So I encourage the new C.J.N. to start with laying the foundation of having some standards, minimum standards in terms of employment, in terms of promotion. Then they should commence the indirect decentralization of the various appellate courts, in the sense that they reduce the work volume, cases that are not contentious, cases that are not that other means of dispute mechanism can be adopted, like the alternative dispute resolution mechanism. Let's start looking at ways of decongesting the court, and making sure that the National Assembly, in advanced climb, is what the court pronounced that the National Assembly will translate into law. For example, there's a judgment that says there's a lacuna in a particular act. The National Assembly now are expected, because that is the law as at the time the court makes the judgment, even though there's no written provision to it. It has gone through many processes to look at the intendment of the judiciary, of the legislators, the circumstances they found themselves, and they've come up with a solution, maybe as a way of necessity. What is expected is that at the next legislative assembly, the legislators are now supposed to take that judgment of the court and properly legislate it as a law. Then they can now make some additions.
You are saying this when most of them do not know anything, and the aides they bring on are probably political cronies that knows nothing.
We have instances where you have aides appointees, somebody that's supposed to be judicial supporting staff. He's only collecting salary, he's not doing anything.
Nothing.
Some are abroad working, where the judges they are supposed to be supporting, then they'll be left to now do those Herculean work. So the right people are not being employed.
It bothers me really, because you are now running an inference to the National Assembly, and honest to God,
and it goes back to the judiciary. We have similar instances
because you need to go there and see. Most of them go there for 8 years, they won't utter one sentence.
No,
it's not because they won't utter one sentence, it's because they have nothing
to offer.
Nothing
so
to
it's simple. They could have just used some of the pronouncements made by the court, dust it up in relation to any phase of human endeavor. On electoral act, they made a pronouncement on aviation, on military relations. So you just have a corpus of such kind of laws, and you can now make amendment of the mother establishment law, so that all the lacunas that have been identified will be taken care of.
Thank you. Along these lines too, I would like to go further by saying one thing. There should be, I believe, in life, there's what is called division of labor.
Sure.
Shouldn't there be a case in the Supreme Court, in the system of the Supreme Court, where some courts are made out for maybe commercial cases, some for labor cases, some for criminal cases? You mean really having that division, and not a case of where a judge is there seated, today is talking criminal, tomorrow is talking law, tomorrow is talking labor, next tomorrow is talking about land. What do you think about that? Because we made our survey, it would have been better, because there was lately there is a demand that there should be a court for political cases, so that it doesn't burden the everyday court that handles other cases of criminal, commercial, land, this or that or that. Shouldn't we have that? A specific court for a specific parameter.
You see, unlike other regular courts, the Supreme Court is an appellate court.
Okay.
That means judgment has been handed over, and either party are not satisfied with it.
Of course.
So you now need a third party to adjudicate over what the judge at the lower court have done. So it's not like they are starting afresh, they are writing, they are doing anything afresh. They are only looking at, as the judge made any mistake, he's a human being, he's susceptible to make mistake, but since he has made it as a judgment, it's no longer a mistake. Only a judge that
is that the norm? That the norm. The moment it becomes a judgment, you don't have to look at it if it's a mistake or not.
No, look at it. If a judge makes a mistake based on his observation, and he has made a pronouncement as a judgment, that judgment stands no matter how bad it is until it is overturned. So the duties of the Supreme Court justices is not to now go into the root of the matter in terms of if the judge actually appreciate whether it's a labor related matter, whether he has capacity to adjudicate. The system at the lower court should take care of that. If you go to states like Lagos, you have judges that are specialists in corruption case, but other crimes, you see, jurisdictional, because we operate a federal system, every federating unit has its own peculiar law. That's what most people don't know. The law that obtains in Abuja is different from the law that obtains in Lagos, even in Kaduna. If it's penal code, if it's any law at all, the state must promulgate its law. So the judges in those states are interpreting that law based on what the states are promulgated. And that is why you see what we did is that we copied the American system, but we copied it wrongly. The American system,
also,
yes, the American system, they have Supreme Courts in each state. So if there's a judgment if there's a separation of courts in those states, the judgment will end in the Supreme Court of that state. Then on federal related matters, then it can now come to the Federal Supreme Court. In our own case, the Supreme Court consists or should consist of 21 panelists.
Okay.
They are multiversatile individuals. They've gone round the various court system, including Sharia law and everything. So what they do is that for every case, they constitute a panel of 5.
Okay, an odd number so that
they can be a winner. At the end, this will say, I have read this judgment of the lower court, and in my mind, now they are giving them that discretion, they are giving them that opportunity, since they have really gone through the expectation, through a lot of, they've seen similar cases, they've done, the idea is that a lawyer should be able to, a good lawyer should be able to have an idea, a relative knowledge of everything. If you don't know, you can do extensive research. So that's why they have legal aids that should be backing them. So now we want to use their objective mind to now say, okay, based on the facts presented before them, based on the preponderance of evidence available to them, they think that this thing should be done this way. They equally make mistakes.
Of course.
But because they are supreme, they have to be regarded that their judgment is supreme
too in word too. Yeah. let me throw in one curve here. We've had instances of conflicting judgment and then taking a matter that is important out of Abuja and take it to one court in one state and then go and get a judgment somewhere and then throw that judgment on the populace of Nigeria, which happened in the case of Section 8412.
Sure.
Where do you lay the blame for that kind of an occurrence? I'm using Section 8412 of the Electoral Act as an example. Where do you lay the blame for a situation like that, that is conflicting in the law, that makes the average layman in Nigeria confused?
You see, legal practitioners are supposed to be people of high noble character, people that are like good examples to the society.
Of course.
So when you now have systems, the law can never be all-encompassing. Laws are made based on the exigency at hand.
That's right.
You cannot predict everything that will come to play. Nobody ever envisaged that somebody will leave Kano and will rush down to Imo because they have a federal high court. As I said, later on, when we discovered we had these challenges, that was where the idea of the federal high court now comes to play, whereby you want to have a court that has federal jurisdiction all over the country. The jurisdiction is not restricted in Kaduna, in Abuja. If you approach a federal high court and you want to punish or you want to litigate, what it means is that I can be in Abuja, but I can choose to go to Lagos to go and file a case, because we are in a federating unit, and the issue that borders that I'm litigating on has a flavor of, in most instances, states equally have jurisdiction on those kind of instances, state high court. But what that means is that I can only file in Abuja or in Kaduna if I'm in Kaduna. I cannot go to Lagos if I'm going to the high court of a state in that kind of instances. So now the question that will come to bear is, what factors, what circumstances will want to warrant somebody to leave his jurisdiction? So you see the element of judicial rascality in there.
Of course, because we the lay people, we are looking at it different.
Even the judge is supposed to, or the registry in this time around, is supposed to discourage that. But they do that for convenience. If you look at the intendment of those people that promulgated those laws, I have you as a client, you are in Lagos, and the court says for any affidavit that you are deposing to, you have to go there physically by your own self, and before the commissioner of oath sign those documents. Insecurity, cost of living, I don't expect you to leave Lagos and start coming down to Abuja because the commissioner of oath in Abuja wants to see you. Because it's a federal court, you can easily go to where you reside in Lagos. Before the commissioner of oath there, You attest on the document and you just send it by waybill, and I will get it and I will be able to file. If you are now seeing the good intendment of why it is a federal, not the issue of the abuse, that because you have somebody in Imo that you believe will give you a favorable judgment, then you now leave Abuja. The question is, why are you going to Imo to go and file a case that you could have filed here? You are not bringing the instance of witnesses or anything. You are just doing forum shopping. You are looking for a judge or a court that is
favorable to your cause.
To your cause, and then you'll be able to get the kind of judgment that you need. And this is discouraged because it shows the pains judiciary in a very bad light.
Okay.
And you look at for the judges, some of them, their hands are tied. If you bring such kind of case to him, he look at it, does the law allows him to adjudicate upon such kind of case? The answer is yes. No. He will adjudicate, but now the harm, so to say, not legally but morally, has been, because a lot of people will start asking questions, why this? And if you now look at it, by their training, judges should not be having conflicting judgment.
Of course, it's not good for the system,
because the litigant will be confused. You don't know what you expect from our courts anymore. And there's element of predictability, whereby you know that if you go to court with the same facts and circumstances, you should be able to get to an extent the same outcome in terms of judgment. And that is why 90% of the bulk of adjudication is done based on precedents of past decided case. That's why you hear in the case of Bakare versus Ahmed, 2003. So you are now calling on the judge now that said, okay, in that case, based on the circumstances that are similar in nature, this is what the judge did. So you are calling on him that you should be able to do same with what you have before you. So in a circumstance where for no good reason, the judge did not specifically state that, no, I am departing from the earlier judgment because he has strong belief that either it was done par incardum, that's the element of mistakes there, or for good reason he needs to do it differently, just for no consideration at all. He's giving a completely different judgment. The litigant will be confused, the lawyers will be confused, and even the general public too will be confused.
On that note, I would like you to give me your last word of what we should expect, or you as a legal practitioner, what are you expecting from the new acting C.J.N? What are your expectations? Because one thing, I would like to tell Nigerians this. How I wish our new C.J.N, our acting C.J.N, will be listening to this, because I believe one thing, nobody has the prerogative of intellect. My brother here, Barrister Ahmed Tanimu, is giving us the bits so that we, the lay people, they call themselves learned. It's like they are the ones that they are the only ones that went to school, whereas some of us are more learned than they are. But the idea is, let him tell us what we can understand and what we can expect from the acting C.J.N. Kayode Aruola.
First and foremost, I expect him to hasten up with the decongestion of the cases that are lingering in the Supreme Court.
That would be good.
He needs to get competent hands, consultants, to kind of advise on how to make the process to run faster and in a more effective manner. Then he should be able to carry along all his colleagues and see them as equal. So you now have, like, I don't know how they do it before now, but they should be able to sit, they should be able to marshal out their diary, they should be able to work as a team, so that in the case of when one of them is not be able to perform its function, they should be able to cover up in terms of there's a backup, there's an arrangement, the system should be able to work. The effort needs to be done to seeing that things are done properly, and the concentration should not be about the Supreme Court. His own focus should be how to ensure that adjudication at all levels are done in an expeditious manner, so that things will be able to go seamlessly. Issue of the welfare issues are issues that are well identified, and for some we believe that there are a lot of income leakages. Some will say corruption going on. Yes, in a way you have to now, if you believe or if you have reason to suspect, setting machinery to curb those income leakages. There's nothing much in getting an inverter that could take even fridge and